here.
Okay, well, thank you everyone for joining this morning. This is the J&J Investor Meeting. It is approximately 9:30 a.m. Pacific time on August 17th, 2026. There are some investors in the room with me today, as well as those of you who are joining on Zoom. Before we get started, I want to do a quick legal and accounting disclaimer. Anything you hear on this call should not be construed as legal advice, nor should anything you hear be construed as accounting advice. If you have specific questions, we would recommend you reach out to competent counsel or to a competent CPA to ask those questions. And any reference to anybody in this case, they should be considered innocent until proven guilty in a court of law. But with that, I want to get started. We did get a number of questions that were submitted to us, and we will get into that. But before I get started, I just want to reference that as many of you probably saw on Friday, we did file our motion for distribution. That is basically to allow us to do an interim distribution as quickly as possible. We've submitted that to the court. The court does have to wait through a period of time waiting for people to possibly object to it. Then once that runs, we're going to ask the court to sign that as quickly as possible so we can get the first distribution out the door. What that means, though, is there are still some claims that have not been fully settled. There are the 37 that were referenced in the court order, as well as some claims related to HTC. If somebody has a claim in one of those two buckets, the amount of money that they would get paid out, assuming that their claim was approved, is going to get withheld from the distribution. So those funds are held back so that once those claims are decided, then we will make a distribution on those claims as well. So we're not giving that money out to anybody else. It is being reserved for those potential claims to get dealt with as part of the process. Our hope is that the court will sign that order as quickly as possible so we can get those checks out the door. That will be the first of what I anticipate will be at least 3 different distributions. We anticipate that the Wells Fargo funds probably will not be received based on the timeline that with the class action case and the civil case that we filed. The last hearings are currently scheduled for November, so it's unlikely that those funds will get to us in time to get in this first distribution, but we don't want to hold off. We want to get that money out as quickly as we can. So we do plan to do that interim distribution as soon as possible. The distribution motion is written in such a way that as we get sums of money into the account, that once it makes sense, it's enough money, then we will just do distributions on an interim basis until the end of the case. And so I think that when we get the Wells Fargo money in, we will do a distribution at that point as well. And then if we get other large chunks of money in throughout the case, we'll either try to distribute it as part of the Wells Fargo, or if it comes after that, then we will do a distribution after that point. Again, it's just got to be a sizable sum of money, enough to make sense to do a distribution until we hit the end of the case. So that's good news. I'm excited about that. I do think that means that, barring some big, some big objection or complaint, that we should be able to, see those checks go out, hopefully in early September, maybe mid-September. But again, we want to get them out as quick as we can at this point. And for those people that are concerned about their claims, that don't have approved claims yet, that are part of that small group, those are getting held back, and those will get distributed as soon as those are dealt with. We have set timelines in place for HTC to get information, and if it isn't received by the end of this month, then we're going to move forward with our calculations based on what we believe to be accurate. And then those 37 claims, as you know, there's a time period set out with the court. It's a 30-day period they have to respond, and then we have 30 days to respond. We don't anticipate needing the full 30 days to respond. Our hope is to try to get as many of those dealt with as quickly as possible during this 30 days. And then if we do need to, we will file something with the court quickly thereafter once our time period starts. I'm going to get into the general questions now that were asked. Some of them are going to cover the distribution. And so as I run into those, I will skip over those and we'll just continue through the other questions. Once we get to the end, I will allow opportunities for people in the audience to ask questions. It'll be a little bit more difficult to do that on Zoom. But if we do see a question that comes up repeatedly that isn't already answered, we will attempt to get that answered as well. With me in the room, I have Garrett from my office, as well as Kara Hendricks from Greenberg Traurig. They were kind enough to give us this space without charging us, so that there's no extra expense to investors to have this in-person meeting. So I do thank them for that. They've been very helpful. In fact, I went and met with Anthony Alberto, one of the defendants in the case, a few weeks ago in New York, and they also gave me office space there, so we didn't have to rent a space to meet with him either. So we do appreciate that. I'm going to get into the general questions first, and then we'll kind of work through the other sections as we get to them. There's questions about meeting times and how often we meet. We try to meet once a quarter. We try to do it in approximately a 90-day period of time, but we also try to line it up with kind of what makes sense in the case as far as like the meetings with the court or the hearings with the court, as well as just trying to get the timing to make sense. And this one, it really made sense because I had to be here for the hearing anyway. So it made sense to be able to do this meeting and the hearing at the same time. We are trying to keep them right around 90 days. But again, if you guys have specific questions, you're welcome to reach out at any time. You don't have to wait for the next investor meeting to get your questions answered. Second question is, can important updates get emailed as they happen? So we do send out emails. If you're signed up on the website, we do send out emails whenever we post any important documents to the website. For example, when the distribution got posted on Friday, we did send out an email along with that saying that it was posted. So if you're signed up for those updates, you should be getting that information already. Next question is, who makes decisions for the whole group? That's actually a very good question. In various different types of cases, you have different parties who are responsible for the decisions that made in this case. Ultimately, in our case, the judge is responsible or the judge makes the final decision on everything in the case. That's why you see we file a lot of motions, and then the court looks at them and either decides to approve them or deny them. I do make recommendations to the court. As you saw in the distribution plan, for example, we recommended that it be a pro rata distribution after doing some analysis. And the court will ultimately decide what the best method is, but that was our recommendation in this case, given what we know about the investors and how they invested. And again, if you have questions or if you have comments or you have ideas, we are always open to them. So if you have a suggestion on a way that we could do something better, or if you think that there's information that could make things easier, please do reach out to us. We are very open to that and are willing to talk with people about their ideas and suggestions. The next one is, can you add meeting notes to the website? So we do post the video links on the website. If somebody was interested, we could have the transcript generated, using like AI to generate a transcript of them. But the actual video itself is available. So I would recommend, if you have questions or you want to see those, that you get on and you can watch them. Next question is there efforts being made to incorporate AI into this case in order to reduce costs? We use AI where it makes sense. Obviously, we deal with a lot of private investor data, and so we're never going to upload that to AI because I don't want that information into the public sphere in any way, shape, or form. We will use AI where it makes sense, and even the software we use to do forensic accounting has some AI basis to it. But we don't just use ChatGPT or some of the other apps in general ways, because we want to make sure that investor data is protected. And we want to be very, very careful with that. Even names, addresses, phone numbers, everything we protected, because we have concerns that that information can be used against people, especially given the amount of fraud that exists in the world today. Who is the judge working on this case? The judge in this case, her name is Christina Silva, and she is in the district court for the District of Nevada. She is a federal judge, Article III judge appointed by the president and confirmed by the Senate. And she is our judge in our case. Next question is, why is this taking so long? And I know from your perspective, it is taking a long time, and I understand that. What I would tell you is it's actually not been a long time, but it does feel like it. In these cases, I say they typically take 3 to 5 years. Not that there's any typical case, but usually a receivership will take at least 3 to 5 years. We are kind of in the middle of that time right now. We're about the 4th year. But as you see, a lot of what we're doing is ramping up, getting towards the end of this. We have a second round of assets we're collecting. We have litigation against third parties. And really, those are the last 2 big things we have to do in order to get the case closed. Now, how long that takes depends on how many people fight it versus how many people willingly settle with us. We've received a number of settlements already, well in excess of $10 million. So we're thrilled about that. But there is some litigation, obviously, that has occurred and will continue to occur. Our hope is to get that pushed through as quickly as possible. We are seeing a number of AI-generated responses to our litigation, which unfortunately does slow down the process some. The court's got to, look at each of those motions to determine whether or not it's properly filed, and then whether or not we have to respond to it. And so that is creating a little bit more work on our part. Our hope is to get through that as quickly as possible, though, so we can get this third-party litigation wrapped up as quickly as possible. With that being said, I do believe that there is additional third-party litigation that will occur against a few different parties, and we are working on that and hope to get that dealt with soon. My hope, though, is that those cases will be something that we can get wrapped up fairly quickly. Next question is, how much of the recovered money has been paid out to the professionals in the case? I don't have the exact number on me. That information, though, is published every quarter. So in our reports, we list out how much money has been paid to every party in the case. And it's all public, including our fee apps. You can go through them and look at them as well. That's all on there. These cases can be expensive, especially in this case where we had no real records to work with. We had to recreate them from scratch. And then you see, as part of that process, everybody wants to fight against the information that we produced. Although the information is accurate, and it has allowed us to file these suits and it's allowed us to set these claims. So we do look forward to pushing through that process and getting that wrapped up. My hope is that it'll be quickly. You guys will see we have not filed our fee app yet for this quarter. It's going to get filed the next day or two. You'll see that our fees dropped in less than half of what they had been in any previous quarter, and they will continue to be low now that we've gotten through all the big pieces of the case. The next piece, like I said, is collecting and selling assets. Not a ton of work there, and then of course the litigation, which is being done by my counsel. So you'll see that the fees, especially our fees, will continue to stay low throughout the remainder of this case. The only bumps that we might see is, if we get into litigation, we have to go to trial or something like that. There could be some additional work that needs to be done there. But otherwise, we think that we are now kind of on the backside of the hill and going down, and will continue to go down. Next questions have to do with the distribution process. So I'm going to go through these. Like I said, a lot of these may have already been answered. So to the extent they have, I generally will not repeat them. The first one is just what needs to happen before a distribution can occur. The easy answer is we just have to wait for the court to approve it. And so if like I said, there could potentially be objections. I don't know why there would be at this point. I think that like I said, we evaluated. There's a few different ways to do a distribution plan. Pro rata is the most common. That means that everybody gets an equal percentage of their allowed claim. There are a few other ways of doing it, like a waterfall or some type of hybrid type of distribution. We actually calculated them all out to see what we thought would be the most fair given everybody's situation in this case. And based on that, and the fact that we anticipate recovering over 50%, a pro rata distribution makes far more sense than any other type. Not to mention, it's also the simplest, the easiest for everyone to understand, and the least objectionable because the Wells Fargo settlement is set up. It has to be done pro rata. And so it'll allow that to fit in a much easier way. So that is the next step really is just waiting on court approval. My hope, like I said, is that, that generally speaking, assuming that there's no objection, we would anticipate the court could sign an order as quickly as the end of this month. And then it'll generally take us less than a week to get those checks in the mail and out the door. Let's see, when can we expect to receive claim monies? Again, that's based on when the court approves it. I would tell you that within 7 days of when the court approves it, we will get those checks in the mail. That part of the process is simple and very inexpensive. It's really the cost of postage, but it generally goes really, really quickly. And so once those checks go out, we will send a notice out to all investors saying the checks are in the mail and to be looking for them. And for some reason you don't receive it within about 3 weeks, do let us know. Unfortunately, with the Postal Service and the delivery times, 3 weeks is unfortunately more common than it ever used to be. But do please give it about that amount of time. If you have not seen your check, then do reach out to us and let us know. The checks are valid for 90 days. And so you have up to 90 days to cash them. If it happens after that point, we reserve those funds for that claim. And so if for some reason we get a check back after 90 days, we'll hold those funds. And somebody can either reach out to us and we'll send out a second check, or it will automatically go out with the second distribution. So that person would get their first distribution and second distribution together. But again, if that happens to you, please do just reach out to us and we'll get that taken care of. Next question is, how can I find out my claim number? If you do not already know your claim number, just reach out to our office. You can send an email or make a telephone call to us and we can get you that claim number to make sure you know what your claim is. If you've received any correspondence from us regarding claims, that claim number will be included in that, and that's where you can find it. But again, if you need it, just reach out to us. Email is probably the easiest way, and we can get that right back to you. Next question is, who decides what checks get cut first? All the checks get cut at the same time. There is no priority to whose checks go out in the mail first or second. We do them all at one time and get them all out at the same time, so they will all go in the mail the same day. If it's given the number of checks, maybe that we get half of them stuff one day and half the next, but they all go out at the same time. Let's see. One of the questions is, we have approximately $78 million in free funds that are not being held back for some reason right now. And we determined that we were going to distribute $70 million in this first distribution. And people are like, well, why is that $8 million there? Well, that $8 million is there for a couple of reasons. Number one, to professional fees. But number two, it's to ensure that if any taxing authorities come forward with a claim, that we have available funds to be able to deal with those claims without having to try to claw back money from investors that we just paid out to them. So we always reserve some of that money. In fact, there's a lot of receivers that will not distribute funds for 3 years past every tax return, because they want to ensure that the taxing authority doesn't make a claim to that. We do our taxes internally. We have the staff that have looked at it and feel like, what our maximum obligation ever could be, and we want to distribute everything else outside of that. I do belong to an organization that is working on getting something called a prompt determination, so that would even allow that process to happen quicker, because essentially it gives the IRS 90 days to review a tax return and decide whether to audit it or forever hold their peace on it. So hopefully we will be getting that soon to even speed up that process even more and give us a little bit more assurance there. And courts are also very hesitant to approve a distribution of funds. In fact, in one of my other cases here in Las Vegas, the court made us hold off because they were concerned about the potential administrative claim that a taxing authority could make. So they asked us actually to wait on a distribution. But fortunately, in this case, like I said, we have comfort with what we think those numbers are, and we'll be doing that distribution with just a small holdback on it. Questions around timing of payment. I think I've been pretty clear on that. There are questions about the 37 investors who we have filed either a partial or full objection to their claim, as well as the HTC investors. Again, I want to make sure it's very, very clear. Based on what those claims are, we are holding back the amount of money that they would receive in the distribution. So out of that 70 million, it's not a lot of claims, it's not a lot of money, but we are holding back that amount of money so that if the court approves those claims, we will then pay it out of that same $70 million. If ultimately the court decides that those claims are not valid, that money goes back into the pot and will be distributed in the second distribution pro rata out to all the approved claims. But this way, there's no, we don't get objections from these people saying that, if my claim gets approved, then they're not going to have any money for me. We eliminate all those objections by just holding back that money. Again, it's a very small amount of money. I think it's right around $1 million total. And so, in the big picture, that's not much money. In order to try to alleviate any objections with the distribution process, we want to, again, try to get that pushed through so we can get these checks out the door. I'm just looking through here, same questions, basically same. Next question is, how long do you anticipate the judge taking for a decision on the payback on that motion? Again, there is a mandatory, period, an appeal or an objection period, so that period would need to run first, and then it's based on the court schedule. My hope is, that we have a hearing today, and one of the things that we're going to talk to the court about is asking the court just to decide on that on the merits of the motion once the appeal period is run. That way, we don't have to have a second hearing, and it doesn't slow down that process anymore. We do feel like it's important to get these checks out. We obviously want to get them out way before Christmas, if at all possible, or the end of the year. For tax purposes as well. How many distributions are you predicting? Right now, I would say it's going to be at least 3. There'll be this first distribution, there'll be a Wells Fargo distribution, and then there will be at least one final distribution, but it could be that there are 2 or even 3 final distributions. Again, if we get enough money in, we will distribute it out as soon as we get a sum that makes sense. I'm not going to probably distribute a couple $1 million, in the middle of the case, because it just doesn't make a lot. The checks are so small, it doesn't make a lot of sense. But if we get any sizable amount of money, we will do distribution on it, because that distribution order allows us to do a distribution whenever we have a sufficient sum of money. So we don't have to get separate court approval for each one of the distributions. Obviously, the exception being we have to go through this Wells Fargo process. The approval process is part of the civil case and the class action case. Like I said, those deadlines fall in November, and then there'll be a short period of time afterwards that Wells Fargo will then take to get us that money. So, if I had to guess, I'm guessing January, February, probably before, realistically before we'd see the Wells Fargo money. Part of it depends on them. Part of it just depends on if there's objections and what that looks like. So, but the hope is that, like I said, that would allow us to do a second distribution sometime in the beginning of the next year. Let's see. Question about Wells Fargo and them waiting to pay. Like I said, there is timeline set up in that case for the objections, especially as part of the class action case. So those timelines have to run before that payment will be made. Next group of questions has to do with Horizon Trust. What happens to the Horizon Trust people that lost money? Will they ever get their money back? Yes, like I said, we were waiting on documents. We sent multiple rounds of subpoenas, requesting documents. We have nearly everything that we need at this point. There's a few more things that we're waiting on. We've already instructed them that if they don't get us those documentations, we're going to go with our numbers because we believe the numbers to be right. And so we will move forward that way if we don't get that information by the end of the month, because it's just gone on too long. And we want to make sure those people get their claims and get their payments as well. Please provide the specifics of what's holding up those claims. We did get all the investor level HTC information. We are waiting on some owner level information because we have owners that are telling us that some of the money went ultimately to investors, and we want to make sure we have an understanding of what money went where. Because if it went from the owner to the investor, then obviously that's belongs to the investor. But if it stayed at the owner, then the owner is responsible for that money. So we just want to make sure that we have an understanding of that. And that's what the last piece that we're waiting on now. Next question is, are there any updates on the case against Jeff Judd, Matt Beasley, and others? On the civil side, I know that the SEC has been reaching out to defendants and working on settling with them. On the criminal side, the only thing I know is that Matt Beasley's sentencing hearing got moved from August, I believe, to October. And that's the only thing that I am aware of at this point as to what is going on in the case. We work on the civil side of the case. Occasionally we will get asked to testify in a criminal case, but that's completely outside of our scope as a receiver. In this case, we only work on the civil side. So we've provided updated calculations on the defendants. You may have seen we filed a report in the court with what we believe the final updated calculations for the defendants and what their personal gain was in the case. And so with that information, the SEC is now working on settling with many of those defendants in the case. It says, are you going after the defendants as aggressively? Yeah, so now that we have those final numbers, we are going back to defendants and collecting additional assets. So we will be turning over homes, cars, and other things like that may still exist in order to try to recover as much of that personal gain from them as possible. And that process is ongoing and will be ramped up in the next 15 to 20 days. We'll be making a big push there. Let's see. Next question is regarding Wells Fargo. It says, during the last meeting, they're informed the attorney fee request of Wells Fargo settlement would not exceed 25% of the funds. In the newly published settlement agreement and class notice, the attorney's fee request is 33 1/3%. Which percentage is correct? So the agreement that I have with the attorneys is that they're going to get paid 25%. They have the right to request an additional amount from the court. However, I will be objecting to anything over 25% and request that the court not pay anything over 25%. Outside of, there are two other pieces to the settlement. There is the fees, or the actual expenses portion for doing depositions and those type of things that under the agreement is allowed to be paid separately. And then there is a $10,000 per plaintiff fee that is paid out to the plaintiffs of the class action suit. I believe that there are 5. I actually requested an update on that. I did not get it. So there would be 5 people that will receive $10,000 because they were named plaintiffs in the case and had to do work in that case in order to help get that settlement to where it was. So those are the only other fees that will be paid out of that. But again, my intent is not to pay any more than 25%. Let's see here. All the same questions. Somebody asked why they don't get to know what the Wells Fargo settlement is. That information is all public now. It was filed. It's all publicly available. And so I would encourage you to go to the website and take a look at the documents if you have any questions on it. What is the realistic timeline on Wells Fargo paying? Like I said, the beginning of next year is the realistic timeline, just because I know it takes time to once the settlement process is done, to push through those last couple pieces of it. What is the date for class counsel to file its final approval and request for attorney's fees? I believe that is going to be done after that November deadline, but as soon as I get those dates, I will publish them so you guys have that information available to you. And again, I will not be approving or I will not support anything above 25%. In fact, I will intend to object to anything requested over 25%, other than the expenses and those small $10,000 payments to those few named plaintiffs in the case. Let's see, is there any progress in any other financial institutions that were complicit? We do continue to look at that. We have not found anything as of today that we're ready to file on, but there are a few that are being reviewed, and we'll hope to be making decisions very shortly on. Next question is assets. What is the total value of the assets yet to be liquidated? We do believe that we have somewhere in the neighborhood of about $100 million in clawback claims against defendants that we will be going after. I don't believe that the defendants have that much money, and so it's unlikely that we will recover all of that. However, our goal is to recover as much of that as possible, and by liquidating homes, cars, jewelry, anything like that may still exist, as well as any other sources of income that we can find. If you're aware of any assets or anything that you think we should be aware of or may not know about, I would encourage you to reach out to us and let us know, because we are always happy to learn about new things, and we're continually looking for additional sources of recovery. Let's see, there's questions about specific people and specific assets that they have. Just know that if you see somebody that has a specific asset and that we can prove that it was purchased with any of the tainted funds from J&J, we will be seeking to recover those assets. Are the funds being held in an interest-bearing account? Yes, they are. That interest, it just continues to build in that account, and then when we do distributions, that's part of the money that gets distributed out would be any interest that we've made. Let's see. Question about why was there a holdup in taking back some of the real estate assets? We have placed liens on a lot of the assets that we know about, but there was a delay because we wanted to make sure we understood what the defendants were responsible for. So we did not go and over collect from them, but now that we have those final numbers, we will be collecting up to the balance of those numbers. Let's see. So that was the questions on assets, and the next section has to do with clawbacks. Do you plan to liquidate second round of clawback assets more aggressively than the first round? I think that clawback is referring from defendants based on the way that's worded. Again, we are going after the remaining assets, and we will be seeking to recover and liquidate those assets. We do that in the ordinary course, though. We don't want to fire sale assets because it does not bring the value. So we will take them and we will sell them in the ordinary course. For example, real estate sold, through a real estate agent, as if we were any other seller, because that's how we can maximize the return on those assets. We don't want to do auctions on the courthouse steps, because that does not bring the value that we need in out of these assets. How much in clawbacks have you recovered, and how much is remaining? Assuming that's talking about third parties, we've recovered over $10 million, settled with over $10 million with the claimants. We do believe that there's over $40 million left to be recovered, and we'll continue to work on that. Have we collected tithing money from the LDS Church? We have been in communication with the LDS Church. I think there was some misunderstanding with them as to the amount of money that was owed back. We have provided them our accounting. They have not given us any information to doubt that our accounting is correct. And we've been in communication with the church, I think, as late as Friday. I think it was the last time we talked to them. So we hope to have an answer on that in the next week or so. If we do not get the answer that we want, we'll be suing the church to get that money back. Let's see. Next question has to do with IRS tax money. We are working through that as we file the tax returns to see if there is a way to free up money that had been paid previously in taxes. It's a little trickier based on the way that some of the tax returns were filed, but to the extent there is any avenue to free that money up, We have filed what's called the Form 56, which is a notice of fiduciary relationship. So if there are tax refunds due, those refunds come to us and not to the defendants directly. So we've done what we can to attempt to get those positioned in order to get them refunded to the extent that they can be. And then the last thing I want to talk about when it comes to the third-party litigation is we've received notification that that some investors who we have sued have had third parties reach out to them about potentially representing them, but they are not licensed attorneys. If somebody reaches out to you who is not a licensed attorney, I would highly recommend that you talk to a licensed attorney about the benefits and drawbacks of working with somebody who's not licensed, who is assisting you. The state of Nevada Bar Association has some very strict rules about the practice of law in Nevada without a license. And so if somebody reaches out to you, we do know that there's an organization that has been reaching out to investors and charging them to help them file AI-generated motions in court, most of which the court has quashed or thrown out because they are not properly filed, not properly titled, are not following the local and federal rules of civil procedure. And so I would strongly recommend that you, if you feel like you need counsel, that you reach out to competent counsel who is licensed in Nevada in order to be able to assist you. But if you are a third party that we have sued in order to get money back, you're welcome to reach out to us as well, because we do have tools and things available to help with payment plans and such in order to help recover any profits that were gained throughout the case if you happen to be in that position. So if you are, I do highly recommend that you reach out to us and allow us to talk and see if we can't work something out for you so you don't have to spend the money to fight a case that we believe that we will win. And finally, just a communication piece. If you want to reach out to us, you want to get a hold of us, there are a few different ways to do so. The easiest is via email, and that is contact@jjconsulting-receivership.com. Again, that's contact@jjconsulting-receivership.com, or you can call us at 702-832-2299. Again, 702-832-2299. And if you haven't already, I highly recommend that you get on our website, that you make sure that you're signed up for noticing. That way, as new documents come in, that you will get notice of those documents and that they've been filed. And that's just the number one way to stay in contact. You can obviously check our website at any time. The newest documents are always loaded at the top of the page, so you'll be able to see them and keep it in contact with what's going on. The docket in this case is almost up to 1,000 documents. So getting them from our website is definitely an easier way to be able to find them, and there's no cost for accessing them there as well. Are there any questions here in the room that I can answer?
You've talked about the Wells Fargo.
Yes.
How many claimants, first of all, do we have?
You mean how many approved claims do we
Yes.
have? I have to go back and look at the exact number. I think it's around 750-ish approved.
750 people, right?
Yeah, approved claims, yeah.
Right. So what I don't understand is the 50 million going into a pot pro rata, or isn't it something where you have a 750 people and you divide that by what's left over after they take the legal fees?
The way that it's been presented in the court is it will be a pro rata distribution of the fees after the attorneys are paid.
Pro rata by the numbers, or pro rata
By the amount of your approved claim.
about your approved claim
Yep.
compared to other people's claims?
Correct. Yeah. So it's pro rata. So if you have a $100,000 claim and that creates a 20% distribution, you'll get a $20,000 payment out of that. And if somebody had a $50,000 claim, they'd get $10,000 out of it. So it's based on your approved amount of your claim. So it is pro rata, meaning it's an equal share of that pot that will be distributed out. Now, the only caveat I would say is that out of the Wells Fargo settlement, if you are a creditor, you will not receive a distribution out of the Wells Fargo settlement because the settlement is only for investors. If a creditor does exist, and there are very few creditor claims, first of all, but if a creditor does exist and has a claim, they would then get that money out of the general funds that are available because everybody still has to receive the same percentage. So if they were due $5,000 out of the Wells Fargo settlement, they wouldn't get it out of those Wells Fargo funds, but they would get it out of the general receivership funds available. Just because there's a specific piece in it, because it's class action, that says it only goes to investors. So and it's only net losing investors are entitled to receive the funds. And so anybody who has a claim in the J&J estate will be eligible for distribution except for creditors. And again, there's only a couple of those.
And do you have any estimate, a ballpark of what percentage you think we're gonna get? Like 28%, 30% of our money back for the first distribution?
Yeah, so this first distribution, I think, when I looked at it, I think it comes out to 28% and change. I wasn't trying to hit an exact percentage. I was really more focused on the main dollar amount going out. So when I did it was 28.2% or something like that, I think is what it was.
So whatever your claim is, you'll get 28% of
Yeah,
that.
exactly, in the first distribution. And then when the Wells Fargo money comes in, you'll get, whatever percent that comes out to be. That's likely to be probably somewhere in that 12 to 14% range, maybe up to 16%, somewhere in there. And then, like I said, there will be at least a third and maybe a third and fourth distribution on top of that, because like I said, we're going now after the approximately $100 million in other assets that we're going to try to recover.
So you think probably about 60, maybe 70% will come out at the end when it's all said and done?
I'm very hesitant to provide a number.
I know, I'm just saying a ballpark.
Yeah,
like an
yeah.
idea.
If I had to guess, that would be
Right.
my guess. Would be somewhere in that range.
Yeah.
We might get really lucky and hit a home run at the end, and we might stub our toe at the end. So it's hard to say for sure. But if things go the way I hope they would go and believe that they can go, then yes, I would say it's going to be somewhere in that range.
So, and I don't mean to interrupt, guys, but 60-70% of what you put in?
Of your allowed claim.
Of your
Of your allowed
claim.
claim.
Of your claim.
Yeah.
Right.
And just so you
Not
guys
bad,
know
right?
too, in a
That's what I'm saying.
receivership, 25 cents on the dollar is considered a pretty good return. So we're gonna get more than that in this first distribution. And so that, I know it doesn't feel like it, from your position, I'm sure it does not. From my position, I'm happy with that first number, but I want 100%. If there's any way I can get 100%, I will do it. But I also don't want to spend a bunch of your money chasing something that is not ultimately recoverable, or get a judgment that we can't collect on. We don't want to spend the money to get a judgment if we don't think we can collect on the judgment.
Is the best way to decide the percentage, you're taking the total amount that you set up somewhere 240 and then divide it by the amount that you put out as that you're gonna distribute?
I mean, that way is a little bit more challenging. It's based on the amount that we're distributing over the amount of claims. So right now the claims are 247 million-ish.
Yeah.
So right now, so you take that 70 divided by 247, and that gives you the
And you'll
percentage.
you'll send out a message that says how much this.
Yeah, we'll send out a message saying the checks are going out, the distribution is in this amount. The check itself will say on it, it'll have your claim number, it'll show your percentage and then the total dollar returned to you at that point.
And one other question is, since you're making a second round of collections, how did you determine what was first and what was second, and why is there two separate?
So what we did is initially we went out and gathered a bunch of assets, homes, things like that we knew existed, that we knew that those parties would be responsible for. In fact, in one instance, we actually over collected from one of the defendants, and we'll be writing them a check back. But we need to appear to be not only neutral but fair. And so we don't ever want to collect more money than we think we're entitled to collect. Now that we know the number, we are going to go back and collect the whole rest of what's out there. But like I said, we did put liens on most of the properties to make sure they couldn't be sold. And making sure the insurance is being paid and the taxes are being paid, things like that.
And the number being what came back from the forensic accounting.
Exactly. Yep. Yeah. And we use not only would we use the forensic accounting, we use the claims process as well. And because we learned more information in that about investor to investor buyouts, cash transactions, things like that. Use information. For example, I got some information from Anthony Alberto that I was able to use. We've met with all the defendants and walked through their numbers and taken information from them as well. So, we have primary source documents, which are bank statements or checks, things like that. And then we have secondary source documents that we use to kind of complete the picture. And that's things that we get from investors, information about days that payments were made, amounts, things like that we can go back and look. At the very end of the forensic accounting project, we had a handful of transactions that we could not identify. And I literally mean like a handful, very few that we couldn't identify. And so if somebody said, hey, I put, X number of dollars in on this day, we would go look at those transactions to see if maybe it was one of those few transactions that would match up with that. But there's very, very little that is unknown at this point. And we believe that those numbers are correct. And again, that's just based on the amount of money that the defendant personally benefited. It's not the amount of money that they received, because sometimes that money went beyond them, or many times it went beyond them to investors or people who helped promoting the scheme.
$50 million from Wells Fargo that was posted, that was a result of the civil suit, and then can we assume that there's gonna be an additional amount when the class action is?
No, that was for both the class and the civil suit. Yeah, they were settled together, because they were under a joint prosecution agreement, which means that both cases were basically being tried and were on the same path. And so the 50 million is the total settlement with Wells Fargo.
Is there, maybe I'm mistaken, but I thought at one point I remembered you saying something about you thought there would possibly be hundreds of millions of dollars. Is this the result you guys were hoping for, or is this less than what you were originally thinking, looking at the documents?
Honestly, it's less than I wanted. I really thought that that was potentially $100 million claim. Part of the issue we had is we never found that smoking gun that would really get us to that 9-figure number. The other thing that that made it difficult is that in the last few years, there have been a number of big awards against banks that have been overturned on appeal. And I know one personally that's now in its 12th year. It just got got overturned at the Court of Appeals, and now, in theory, will be going to the Supreme Court. Knowing all that information, looking at the claim, looking at the evidence that we had against the bank and the stuff we didn't have, ultimately made the decision that that was the best number. And I did not come to that lightly, by the way. At one point, I actually made everybody leave the room, and I sat in the room by myself for over an hour, just really penciling it out, making sense. I talked to the judge about it, to make sure that the judge was happy with it. I talked with the SEC about it, made sure that they would be happy with that result. And unfortunately, $100 million settlement that we litigate for 10 years versus a $50 million settlement that is guaranteed money, ultimately made the decision. And like I said, if we had gotten that smoking gun that we really hoped was out there, I think the settlement could have been higher. But given that we didn't have that smoking gun, and we had a lot of, evidence of things that they should have done or should have known. But unfortunately, in this type of an action where you're, the aiding and abetting liability, it has to be more than just what they should have known. It has to be what they actually knew. And so we could argue that, look, all this money went through their account. That was very odd. And everybody agrees with that. But I didn't have that banker who I had that email from them saying, hey, here's how we can circumvent bank rules in order to get this done. If I'd had that email, this would have been a $100 million case. But we didn't. And so ultimately, like I said, and we went through 3 mediations, just so you guys are aware too. And we mediated between the mediations, that we can't, there's mediation privileges. That's why I hated that, because I couldn't tell you guys what the ultimate settlement was, because until it's published, I can't tell anybody, and it really stinks. But, like I said, we sat through, we worked out all the numbers, we went through all of it. And I believe that is a fair number, a fair settlement. I don't like it, but that's kind of part of what mediation's about. I mean, a truly successful mediation is when both parties walk out hating the result. And that was definitely the case here.
Yeah, I just wanted a quick question regarding the claims.
Mhm.
So if you put in 100 grand, just say, and you receive back, interest back 50,000,
Mhm.
Are they still looking to pay off the 100 grand, or are you only paying the 50?
We only paid the 50 because
That's what-
in these cases, it's considered money in, money out. So it doesn't matter what you call that payment that you got, whether
Right.
interest or principal, because at the end of the day, it was all fake.
Right.
Because there was no actual income made by the company. So anything that was paid out as interest or profits aren't real, because there were no interest or were no profits. So we do it on a strict money in, money out basis. So if you got 100,000, you receive 50 back, you have a $50,000 claim.
How much does the Mormon church owes us in tithing?
It's just over $3 million.
$3 million.
It's just under 3.1 million.
That's part of that line item that says 100 million at the bottom.
Yeah, that includes that and the clawback actions against third-party investors as well.
But not Wells Fargo on that.
It does as well. So there are 2 different numbers. There's the money we think we can recover from defendants, or the amount that they owe. And then there's the amount for third party, which would be the church, it would be the investors, it would be the bank. That would all fall into that category.
I have some questions from the chat. The first one is it possible for a claimant to receive a distribution via ACH or to pick up a check in person?
So usually we do not we try not to do, we don't do ACHs as a general rule because of the protection on our accounts. They're very specialized types of accounts. The only instance where we will generally do wires is for international claimants because they can't cash a check internationally. So generally we will only do those internationally just because there's additional time and cost associated with doing a wire. We try not to do them. At some point, I'm really hoping that the banking system can kind of catch up with what we're doing so we could ACH all this money. And I've asked the vendors that work in this space to work on that because I do believe that that makes more sense. I would much rather do that. Now, I could give you guys all credit cards that are preloaded with the balances, but I don't think anybody wants that. So until we can figure out a way to efficiently do the ACH like that, then I think that unfortunately we're still stuck with checks. Like I said, if there were 8 or 10 of you, I might just wire them all because it'd be easier. But given and not to mention when I wire you money, there's no cost to the estate, but your bank will charge you to accept the wire, and it's somewhere between $5 and $30, I think they charge.
Just send those checks, don't worry about it.
Yeah. And we've had good luck with it. The checks are specially encoded and signed, and so and our bank does not allow bad checks to clear. They're very good about making sure that everything matches up. The name has to match, the dollar has to match, and it has to match what's in our system. So if the check doesn't exist in our system, they won't clear it.
I said the question on the Mormon church. So because it was ill-gotten gains, they have to return the money?
Well, just like any other third party that we are going after for ill-gotten gains, that would be the theory that we would sue them under if they did not voluntarily return the money.
Gotcha.
In the back.
I've got a couple questions. The first one is, I got something in the mail about the Wells Fargo thing. Is there anything additionally we have to do if we have a claim already with you as far as the Wells Fargo?
Nope, it's just
Nothing else to fill out?
that is the class action notice that they're required to send you, letting you know about the settlement. Because the settlement will bar, future claims against Wells Fargo unless you opt out of it. But yeah, that's why it is sent out so people are aware that there is, that this is in process. If you have an approved claim, you're already good to go.
Okay. And the second and actually third part of that is, so as a percentage of our total claim, that Wells Fargo piece, that 50 million, you said approximately what percentage is that of the collected money so far?
I mean, I would have to do the math. I think it's probably right around after the attorney's fees are paid, the third party fees in the class case. And I remember those attorneys are all sharing the same fee. They're not all getting separate fees. But once that fee is paid, then whatever's left after that, which I think will be about 36.5 million, potentially a little bit more than that, that money will go out pro rata. And I think that's about 14% ish. And so I think that'll produce an additional 14% recovery just in and of itself.
Okay. And the 70 million you said in the first distribution?
28%.
About 28. So we're looking at in the first two to get what, close to 40?
Yeah, about 42%, somewhere in that range.
42.
Yeah. And then, like I said, there will be subsequent distributions after that as well.
Great.
But those are the two larger ones that this gentleman that you guys have discussed.
Yeah, I mean, in theory, those are probably, that first one is probably going to be the largest single distribution. But depending on the third party recovery and the recovery from defendants,
We still got 100 million.
that last distribution should be able to should be able to go over that. Yeah, the first two distributions will be about 106 to 107 million, just in and of themselves.
Follow-up question on the earlier question, is it possible to pick up checks in person?
Potentially, yes. If somebody wanted to do that, we could set a time and a place where people could come pick them up if they wanted to. It's a pretty inefficient way of doing it, but if somebody, they would need to be either picked up in Las Vegas or in Portland. And like I said, if somebody wanted, I could set a time and a place where we give a half an hour window. I don't want to bill the other investors, you know what I mean? Because I don't want to sit there for a day waiting for people to show up and bill everybody else for the people that want to pick them up. But if somebody wanted to reach out to us and wanted to schedule a time that we could, otherwise be available, then I would be happy to do that. Again, not a super efficient way of dealing with it, but if there's concerns, we can definitely work on that.
In the receiver for sale of a primary residence?
Under certain circumstances, yes.
how's the liability divided up between defendants?
So the SEC's restitution numbers are based on the personal gain by the individual defendant. And that is defined as the money that they got, that they spent themselves, and not money that went on to a further party. So if the money went to the defendant and then went to an investor, that money is counted against the investor, not against the defendant. If the money went to the defendant and then went to another promoter, generally speaking, that money would be the responsibility of that promoter and not the defendant. So again, that restitution figure is based on what is owed because of their personal gain, what they personally got and spent, versus, some other theory of liability, based on the total amount of money they got or some other theory. But again, that's the SEC's calculate, that is how the SEC calculates it. That's how the courts have told them they have to calculate that number. And again, and there might be fines on top of that, but that is the restitution number is based on a personal profit. Any other questions? Okay, we can go ahead and end the call. And if anybody wants to come up and say hi, you guys are welcome to. I appreciate you guys coming out to see us in person. We're happy to do this, occasionally. My only concern, of course, is, the cost of just having, all the logistics. But fortunately for me, it didn't take any more time doing it here versus just doing it on a regular telephone call. We do appreciate Greenberg setting this up. I think that, should there be any other big news in the case, we could look at doing it potentially in person again. But I think that for the next quarter, we'll plan on doing it online. We should have an update on Wells Fargo and the distribution to that point. And so that will be the plan there.
Did you already publish the quarterly statement?
The quarterly report?
Mhm.
Yeah, the quarterly report was filed, yeah, right. So they're due at the end of the month after the quarter ending. So if the quarter ended at the end of July, we usually file them, I'm sorry, in this case, it ended at the end of June. We try to file it by July 31st. I think this one pushed to August 1st, pushed to the next Monday. But yeah, we always look to file them by the end of that month. Yeah. That way we can update all the accounting records, we can reconcile the bank accounts, and then we file that report, and that report goes through the end of June. Yeah.
Okay.
We're going to go ahead and end the session.
Yeah, go ahead and end the call. Yeah. Thank you again, guys.